Morning, everybody. For those folks who are on, looks like we got about half our attendees signed on so far. So we're going to wait just a few more minutes, and we'll ask our instructor, Mike Catania, to come on here in a few minutes as well. Just want to get most of the attendees on before we start the webinar. Thank you. Looks like we have most of the folks who had registered to attend the webinar on. My clock says it's 10 after 3, so we're not going to keep you waiting any longer. I'll ask Mike Catania, our instructor, to pop on now, and we'll get the program started. Welcome, everybody. My name is Mike Meisenheimer. I'm Executive Director of NESCA. If you're attending this webinar, you're either a member of NESCA, AGC, or ECA, or maybe several of those organizations. We do a lot of our educational programming jointly. Today is the third in a series of webinars on killer contract clauses. I apologize, we had to postpone this from last Tuesday, but Mike Catania, our instructor down in Newburgh, got snowed in pretty good with that nor'easter that blew up the coast. So we appreciate you sticking with us here and attending on Monday. Mike Catania is the managing partner at Catania, Mahon Rider, PLLC, and heads up the firm's construction practice group. He's got wide-ranging experience in construction contract drafting and negotiation, and represents some of the areas leading construction management firms, contractors, design professionals, and developers. He's also an experienced litigator with extensive trial and arbitration experience, including all forms of construction-related claims. And today, Mike's going to cover conflicts and ambiguities and waiver provisions. And before I turn it over to Mike, please, if you have a question today for Mike, if you go down to the bottom right of your screen, you'll see a chat feature. Use the chat feature. If you click on that, you'll see you can ask a question so everybody can read it and see it. So ask your questions in that manner rather than using the Q&A feature. So with that said, I'm going to turn it over to Mike Catania. Mike?
Thank you, Mike, very much for that introduction. Good morning, everyone. I'm going to jump right into it. We have a lot to cover here. So definitely use the chat feature as questions come up, and I'm hopeful we can finish up a little bit early and handle some of those questions. You know, we're going to be jumping around a lot, just the nature of this topic, especially with waiver provisions and where you can find them in the contract documents. But just broadly speaking, I'm not talking about whether any of the clauses that I'm going to go through are actually enforceable, let's say, in a court or an arbitration. Because practically speaking, many of my clients who are faced with some of these clauses, that's not an option. You know, litigation is extremely expensive these days, and arbitration is ticking up there as well. And so you may find yourself at the end of a job, and yeah, it may be over a $5,000 change order or a $15,000 change order, something that may not be worthwhile pursuing as far as the legality of the clause that's in the contract that the owner is relying upon or the GC is relying upon. So it's just not a practical matter to challenge it. So really the goal of this session is to give you some kind of general awareness of what to be looking for when you're reviewing these contracts. And if you, in most cases, if you can't change the language, at least you know if something comes up on the job, I got to take steps 1, 2, and 3 per the contract. It's your best shot at protecting your rights. Okay, so I'm going to jump right in here. So the first part of this is conflicts and ambiguities in contract documents, and obviously we have to start with what are contract documents. Throughout here, I'll be referencing AIA and consensus docs. They're the two most popular. kind of form contracts out there. Many of you are probably familiar with AIA in the Northeast, and consensus stocks is, I'm seeing that more often. And frankly, a lot of the modified contracts that you get from owners are typically based upon one or both of these templates. So it's good to just kind of know the standard language before taking a look at what some owners may do to that, so you could be aware of it. So what are the contract documents? Okay, so the AIA and consensus docs have similar definitions. Typically, right, it's the contract, it's the specs, general, specific conditions, drawings, any addenda, modifications. When I say modifications, typically you're talking about a change order or a change directive. So when those are executed, they become part of the contract documents. Consensus docs also include certain owner supplied information, typically having to do with hazardous materials or asbestos abatement plans, things of that nature. So speaking to the subcontractors, again, you're going to have almost every subcontract, the prime contract will be incorporated. Either it's going to be an exhibit to your contract, or they're going to specifically reference it and say that you're bound by it. Depending upon the contract, you may be bound in the entirety or just to those portions that apply to your scope of work. That's partial or fully incorporated. And again, the law comes in here too. There's cases out there, whether or not you can incorporate, for example, a waiver of a jury trial, or whether an owner, whether a general contractor can force a subcontractor to arbitrate, because there's an arbitration clause in the prime contract where the prime contractor didn't specifically put that clause in his subcontract. But generally speaking, you're going to be bound to the prime contract, and that also means all of the exhibits to the prime contract and anything that the prime contract might reference. So a couple, points here. Number one, your proposal. Is that a contract document? A lot of times you might assume it is. It's what you negotiated. You were responding to owner's request for a proposal, and you submitted the proposal, and they say you have the job. So certainly that's going to be a contract document. No, unless it's specifically set out in the contract. Exhibit C, contractor's proposal dated January 1st, 2021, and the AIA contract says it's not included. And so that includes, and this is important, a lot of times on public jobs, that's going to include the instructions, invitations to bid, sample forms, other information having to do with the whole bidding process. And so you'll see a lot of times in those contracts, they do make addendum 1, addendum 2 will be part of the contract documents. But if throughout the process, for example, you've submitted some questions to the architect, and then the architect has submitted responses to you or to the bidding group as a whole, and those are not specifically put in the contract as contract documents, you got to insist that they are, especially if your bid and the numbers in there are based upon that clarification given by the project architect. So bottom line, don't assume that your proposal or the request for a proposal or even RFIs are contract documents. Make sure they're specifically listed or attached. And you really shouldn't get much blowback from this from either owners if you're a contractor, or GCs if you're a sub, if there was some legitimate back and forth here and your bid is based upon whatever information was supplemented. Make sure they're attached, make sure they're referenced in the contract. All right, so what about shop drawings? Are they contract documents? So AIA specifically excludes shop drawings, other submittals, as contract documents. And consensus docs doesn't specifically say they are contract documents, but they do say that just because your submittal gets approved, it doesn't alter your obligations under the contract. And as you guys know, this can be a big issue in the job where your submittals are approved by the architect or the engineer, and look at the stamp that they use, because they have about 20 of them, and I guarantee you there's going to be some qualifying or language on there that doesn't allow you to supplement anything in the original contract documents. The approval from the architect doesn't mean that your submittal meets the contract documents, things of that nature. So be on the lookout for that. So now you come to the issue with respect to contract documents. You're going to have times where different documents say different things or have different standards, or have different dimensions, specifications, etc. So how do you deal with that, especially on the front end when you're trying to bid the project? So some contracts, especially the state contracts you have here in New York, are going to have an order of precedent clause typically. And all that means is they're going to list out the documents, the contract documents, and they're going to tell you which one controls over the other. I gave you an example here. Consensus Docs actually does this in their contract. They put change orders first, because obviously you're changing the contract, so that should take priority. Then the actual contract, the agreement. And then they list drawings, large scale over small, and then specifications, then owner information, and then other contract documents. Consensus Docs also has some nice saving language here that despite that order of precedence, if there's a term or provision that's conflicting, you're going to use the one with the latest date. If for some reason something's issued a few weeks later, you would use that information as opposed to the original. If you get into your New York agency contracts, DOT, DEP, DASNIUS, etc., you're going to see some specific language with respect to drawings controlling over specifications. You'll also note and point out here the OGS general conditions for New York State. They also say the less stringent and less expensive provisions take precedence over the more stringent and expensive. This is quite nice because it's the exact opposite of what you're going to find in most owner modified contracts, right? They're going to require you to do the more stringent or the more expensive whenever there's a conflict. But New York's OGS general conditions, which are reflected in a lot of the agency contracts, only require you to do what's less stringent or less expensive. I've also seen plenty of times where even within the specifications, division one of the specs, the general is going to trump the rest of the specifications, control over it. So for subcontractors, again, the subcontract is often going to control all the other documents. So if there's a conflict between the subcontract and the prime, there may be language in there that says the subcontract is going to control. To flip it, if you look at consensus docs or if you look at most federal contracts, they actually state that the specifications take priority over the drawings. Again, the New York OGS says drawings take precedence over the specs. So pay attention to it. We all know that there can be some pretty significant discrepancies between drawings and specifications. When in doubt, and we'll get to this later, but when in doubt, as soon as you identify that ambiguity or conflict, give written notice to whether it's the project engineer or the architect and the owner of that, requesting additional information. When you're signing an AIA contract that has been modified, they actually don't have an order of precedence clause. They take what's called a complementary approach. Essentially, all the contract documents are complement each other, and so you're going to interpret them that way. And who makes this interpretation if there's a conflict? Well, it's typically the owner or the architect, which is not going to go in your favor. But even so, your owners often modify the AIA to include language, and you'll see this in a lot of contracts. It's sort of the opposite of what we just looked at, where you were required to perform the less stringent or less expensive. Well, owners typically want you to perform whatever requires the better quality or greater quantity of work, or to comply with the more stringent requirement. Again, you're going to see that the architect or the owner is going to make that determination. So be very careful, when you're putting your bid in, if, especially if let's say you're a GC early on, and the design is not 100% complete, you really want to keep an eye on this. You don't want to put yourself in a position where you're really bidding on one scope, but because the specs that come out later, or some revisions to drawings that come out later change it, the owner can somehow require you to comply with that more stringent requirement. That's why it's so important to have a clear definition of what is a contract document and what is not, and then what takes precedence. Okay? If there's no provisions, which you see sometimes, then you kind of default to common law. I'm not going to bore you here, but there's quite a few drafting, contractual interpretation standards, clauses that the courts use. Typically your specific is going to control over your general. So if you're required to do one thing, but in the specifications, it gives you far more detail on that requirement than the specification. The court will find that the specification is going to control because it has the more information, the more specificity. You're also going to see courts tend to interpret contracts against the drafter, meaning the person who actually drafted the contract. That is why in almost all contracts now you see, at the end of the contract where they throw in a bunch of clauses under miscellaneous, you'll see a clause there that speaks to joint drafting of the contract, even though you may have nothing to do with that. You were given the contract and you had to sign it. You're affirming that the contract was jointly drafted, and that there's going to be no favoritism as far as how a clause is going to be interpreted against one party or the other, which would normally be the default rule. The owner, as the drafting party, it would be construed against the owner as opposed to the general contractor. So, what are the contractor's obligations with respect to conflicts? I mentioned this before. And again, this goes for subcontractors as well. So most contracts do have some kind of document review clause. So with consensus docs, it requires the contractor or the sub, you have to examine, compare the drawings and specs, the relevant field measurements, any visible conditions to the work site affecting the work. And if that review pops up errors, you have to promptly report them to the owner. AIA takes a similar position. Again, you got to review the contract documents, make sure they comply, make sure the field measurements are correct. Of course, the question comes up in both of these situations, well, what if you don't? So importantly, consensus docs, realizing that this can kind of, I think, shift into kind of an improper delegation of design. You're a contractor, your means and methods, you should not be tasked with reviewing the plans to make sure they meet code, to make sure anything that has to do with design or engineering aspects of it. So in that vein, consensus docs actually state specifically it's only meant to facilitate construction. That you as a contractor have no responsibility to detect errors, omissions, inconsistencies, compliance with the law, building code, or regulation. That's very important language, and it's language that is not found in many of the owner-modified contracts. And again, you have to be very careful with this because you start to get into insurance issues. Whether or not your general liability is going to cover a claim by the owner with respect to a failure to detect an error of the plan, things of that nature. So again, it's to facilitate construction, to detect errors, omissions. So the AIA, again, has some good language in it that the review of the contract documents is only for the purpose of facilitating coordination and construction by the contractor, not for the purpose of discovering errors, omissions, or inconsistencies. With the AIA contract, if you're getting a modified AIA contract, whether you're a sub or you're a GC, it should be redlined, so to speak. You're going to see on the margins where it's been changed, and it should come with an additions deletions report either attached to it, or it should actually be redlined in the agreement. If it doesn't, you need to ask for it. Don't assume that you're signing the form contract, because you likely are not. And things like this may be taken out or altered, and you may not catch it. So even with this language, though, you can't ignore errors in the contract documents that you discover. And that goes for AIA, goes for consensus docs, and also for subcontractors. I gave you some example language from consensus docs here. Subcontractors not going to have any liability, for the errors in the contract documents unless it knowingly fails to report a recognized problem to a constructor. Consensus docs calls the contractor constructor, and AIA calls it contractor. It's kind of one easy way to know what contract you're dealing with. Now, I said from the owner's perspective. So this is typically what a private owner may do on a large job, especially one that use the architect for the plans, but the architect's not doing construction administration. Maybe it's an owner's rep. Maybe it's a CM not at risk, and you'll see language such as this. So they're going to put language into the clause we just looked at. It's actually going to hold. You have to hold them, the owner, harmless for any error or conflict that either was or should have been discovered. And the should have been is the key here. There's a specific acknowledgement also they put in there that I, the contractor, have reviewed the contract documents. I find them sufficient and complete, and they were accurate enough for me to determine the correct contract sum, the correct contract time. All this language is put in there to prevent you from later claiming either by a change order or a claim, extended time, or in addition to the contract sum, for issues that come up as a result of the drawings or the specifications being out of whack, being out of code, requiring something else entirely. You having to go back and redo work because of it. So prime contractors then often make kind of similar revisions to their subcontracts. Again, everything gets pushed down, right? So I've seen this, whereas the subcontractor shall not at any time make claims alleging insufficient data or incorrectly assumed conditions or conflicts in the contract documents following execution. Now, this is a pretty tough clause here. Again, I'm not discussing whether or not this would be enforceable in court of law, because quite frankly, you're not going to be able to test it in most situations. If it's being used against you, you're going to have a difficult time here. So be on the lookout for this. You may not have much power as a sub, but I find that you often can at least negotiate 2 or 3 key terms to at least be back to the default rule. You may not be able to get them in your favor, but at least to a more level ground. The same goes with contractors dealing with owners and their modified documents. Reasonable requests for changes, I think, are often at least considered by the owner. All right. You also are going to see that the contract review, and this is really important, it's not just confined to the contract or the general terms. And many of you who work on public jobs know this, right? So you get the project manual, part 1 and part 2, because they're so big they can't fit in one email, and it has all the specs in it. A lot of times the architect is making up that spec, puts in contract review requirements or work review requirements that are not in the prime contract. And it's not till later that you realize, when you get the letter from the architect citing some obscure specification as to your requirement to give notice on some issue, that, oh, okay, this also applied. It can be buried sometimes in these huge spec books, but be on the lookout for them. And I'll give you an example of something I recently saw on a public school project. Again, in the specifications, not in the prime contract or the general conditions or the modifications that were made by the owner. This was in the specifications. And it required the contractor to immediately, when he discovered issues with respect to contract documents, they had to submit a request for information to the architect. And here's the key part: failure to do that timely was an express acceptance of any such differing site conditions, and the owner shall not be required to make any adjustment in the contract sum or contract time. Now, obviously, the architect's putting that in to save, you know, its own butt. This is, and the way I've seen this applied, it really can be egregious. So, what's the answer? You know, if you can't make revisions to it, you're stuck with it. Highlight it, put it on the front. Let your project manager know on this job, if there's ever an issue, here's a template letter. This has got to go out ASAP, you know, and cite the specification in the letter. Never waive a claim because of a failure of written notice. It's once you have that system in place, it's something that you can easily do, especially on the larger jobs where with public owners, that, you know, no one's going to get too offended by receiving a notice of claim on an issue like this. And I call the owner, call the architect up beforehand, say, look, I got to do this just because of the specification, so expect this, and you know, you can move along. But at least you have that documented, and you show that you followed the required notice provisions. Again, if you've deemed to accept the site condition and all its flaws, then you're going to be on the hook for, you know, any additional work required to actually bring it to where it was supposed to be per the contract documents. All right. Second part is waiver provisions, and this all relates. We've already talked about, you know, some waiver of claims with respect to contract documents. So by waiver provisions, you know, you're looking at various parts of the contract. It can apply to means and methods. It can apply to claims you may have with respect to others, you know, separate contractors' work or interference. It can apply to different site conditions. It can apply to delays. It can apply to acceptance of payment and lien waivers, which is the final thing we'll look at today. So what's a waiver? With respect to contracts and construction contracts, it's a voluntarily forfeiting of your kind of contractual or equitable rights or claims. And you do it either by your affirmative conduct, something you've done, or by failing to act, something you haven't done. So if you fail to review and strictly follow, you know, contractual claim and notice procedures in the contract documents, you're deemed to have voluntarily waived that claim. And I can tell you, in New York, waiver provisions tend to be strictly enforced. You know, when you're dealing with two companies, the courts will enforce them. So don't ignore them. If anything, if you get anything out of this, you know, 45 minutes, know your contract as far as what you might be waiving by failing to do certain things. Don't ignore it. Have a procedure in place on that job. Talk to the project manager, talk to the supervisor, so that everyone knows what to do in case something happens. Because these, I believe you have another session on just notice of claims, but the timelines are often very short, even shorter for subs, right? So let's say the GC might have 7 days to submit prior notice. The sub may have 3 days. So you really have to be on top of it. So again, you know, some deal with prior written notice. They make it a condition precedent, meaning if you haven't done this, then you can't assert a claim. You know, one area where this happens is means and methods, and by that I mean, so you're performing the work in a certain way pursuant to instructions that were given to you or part of the specifications. You know, whether it's the sequencing of the work, or you know, whether it calls for field cuts or not, things of that nature. So typically, you as a contractor are not liable for damages that result from you following what you're instructed to do, you know, from the architect or the engineer. Unless, again, you discovered it, you recognized it beforehand, and you failed to report it. That failure to report is going to be a waiver in many instances. So that not only includes your claim for, you know, additional time or additional monies, but it would also include any costs that you're going to incur to remediate, let's say, failed work, uncover failed work, even though the work failed because of problems with the instructions that you were contractually required to follow. That's why notice is key. What about others' work? By other contractors. So on WIX jobs and on public project jobs, you deal with this often. You got several primes, on the work site, and their scopes often, interact or follow one another, and can be going on at the same time. So, okay, there's a defect in the work performed by another prime or another sub, and it delays you, right? You can't put the electric in until the framing's complete. You can't do the plumbing, until the excavation, drains, etc. There's a sequence to the work, and a delay before you is going to hamper your ability to perform the work timely. So many contracts have clauses that require you, either as a sub or a contractor, when you discover a defect in someone else's work or delay, and it's interfering with your own, you have to, again, give prompt written notification to the owner and the architect. Failure to do this is gonna be a waiver of a claim. If you look at consensus docs, they even consensus docs says acknowledges that the work of owner or others is not defective and is acceptable for the proper execution of the work. So you'll find in owner modified contracts, this doesn't just apply to defects in others' work that you discovered, but that, again, you should have discovered. And you're like, well, who makes that determination? Well, guess what? Initially, obviously, it's going to be the owner and the architect. And 9 times out of 10, you should have discovered it in their opinion. So what do you have to do? I mean, a lot of times owners don't just require simple written notification. They want information and backup and documentation. And failure to give that sometimes is held as a waiver as well. So it's not just enough to give the notice. You have to follow strictly what the contract requires to be in support of that notice, in support of your claim. You'll see this a lot of times. You'll have to submit an updated project schedule. With delay claims, you have to submit certain documentation evidencing how you're going to go forward and why the requested extension is needed and things like that. And you're often required to update it as the project goes on. Okay, what about differing site conditions? So consensus docs, if a subsurface or other physical condition is materially different from those indicated in the contract documents, or unusual, unknown physical condition that's materially different, you're supposed to stop the work that's affected by that condition, give prompt written notice, and then there should be a change order issued per the contract. AIA is also very similar, except that instead of saying prompt written notice, it says you got 14 days to give notice to the owner or architect. These clauses rarely ever go unmodified, and I've given you some typical language that you'll see. Again, it's not just what you picked up on, it's what you should have, right? So conditions that should have been easily recognized via a site visit are your responsibility. The amounts, this amounts to another waiver, right? So as you as the contractor now have to remove or relocate or refabricate installations at your own cost, no increase in contract time or sum. You see language like this: any errors due to the contractor's failure to verify grades, elevations, dimensions, locations, they have to be promptly rectified by the contractor without any additional cost to the owner. That's right. Someone else obviously set the grades. You have documents that show it. You have specifications and plans, and you get there. As a contractor, you're required to verify those grades, and your failure to do so, regardless of the fact that someone else screwed up before you, puts you on the hook. For subcontractors, again, your requirements here with respect to waivers, it's often tied into the prime contract, where it's more stringent. So aside from emergencies, most agreements are going to require you as a sub to give written notice for claims that have extra work, time, different site conditions, and you often have to give the notice prior to starting the work. That's very key. If you give the notice after starting the work, the owner will come back and claim that you waived it. Again, as a subcontractor, you're going to be on the hook for all the related expenses and delays associated with a failure to give notice. One of the final areas as far as waiver, and this gets into lien waivers, is the whole acceptance of payment. What if any claims do you waive as a contractor or a sub when you accept partial or final payment on a job? So AIA standard language says that when you make, when the owner makes a final payment, the owner actually waives claims, including defective work and warranty claims. I'm sorry, the owner waives claims except those arising from defective work or warranty claims or lien claims. If one of your subs puts a lien on it, the owner can come after you for that. For contractors and subs, when you accept payment, again, this is the standard language, then you waive claims except those previously made in writing and identified by you as unsettled at the time of final application for payment. That's very important. AIA does not just require you to have placed the owner or the contractor on notice of your additional claim, but you have to, in your final application for payment, identify that claim, whether it's a change order or extra time, overtime, etc., that claim is still outstanding. And so make sure that's documented. Consensus docs, similar language. It does not require the prior written notice from the contractor. So lien waivers, we often don't think of this with respect to waivers of other rights other than a mechanics lien, but more and more you have to be extremely careful and diligent as far as reviewing and understanding what you're signing. You got 4 types of lien waivers. You have your final lien waiver, right? You have your partial lien waiver, and then both of those can either be conditional or not conditional. Conditional upon payment, or it doesn't reference it. It just basically says you've been paid this amount. The contractor or the sub, it'll have language in there. You're going to waive and release all your rights, as they pertain to a particular pay app. If it's partial, up to this date, or the entire job if it's final, and that's fine. I've given you kind of a sample bare bones lien waiver, where you as the contractor for X amount of money, which you have received. If this was conditional, it might say condition upon payment. The undersigned contractor agrees that shall not in any way claim or file a mechanics lien against the premises, and that there are no rights, liens, etc. on the material that you've provided. That's a pretty bare bones one. Unfortunately, that's not what you're typically going to get from the owner, or if you're a sub, from the GC. So here are some examples. They often, the lien waivers, and especially the final lien waiver, is often expanded not just to include your mechanics lien rights, but it's all claims that you may have, and this includes extras and change orders. So again, you got to be careful with respect to what you're waiving. If there are open change orders, then you need to put that in there. Here's an example: claims for additional costs or claims for any extras or additions for labor materials relating to the contract, and the contractor is not aware of any such claims by others. So that's some language that they include in there to have you waive. And so I have here, what about your pending change orders? Make sure there's some language in there about them that accepts it, at least acknowledges that pending change order number 4 is still under review and is not part of this waiver. These waivers also tend to include another paragraph that has you indemnifying and holding harmless the owner, or if you're a sub, the contractor, And it's an indemnification provision that can sometimes be broader than is what's found in the initial contract. So you may be fine with the indemnification clause in your initial contract and not think twice, and then you sign the final lien waiver and you realize that you've agreed to a far broader indemnification paragraph. So also with respect to delay claims, I see this a lot lately. In the lien waiver itself, it'll say something such as contractor warrants that has been not been delayed in the performance of his work to date, and that has incurred no extra cost in connection therewith. So you sign this on a partial lien waiver or a final lien waiver, and you try to assert a delay claim later on, you're out of luck, frankly. What you sign to get your payments here is just as important as what you initially signed to get the contract. So make sure you read the lien waivers, and make sure if you're a contractor that your lien waivers that you're having your subs sign protect you based upon what you're required to warrant or waive with respect to the owner. Subs, it's the same thing with your own subs and suppliers. And just some final notes here, with respect to lien waivers, just a reminder, an owner can't require you to waive your right to file a lien in advance of being paid. That's void against public policy. So, however, contractor or sub, you can waive and release your lien rights with a written waiver, either with or after payment. That is provided for. Frankly, I think the conditional lien waiver, which you find on a lot of public jobs, is something that you should be looking for. It could simply having the language that states, it's conditioned upon payment, because 9 times out of 10, you're submitting that and you haven't been paid, but you're representing that all of your subs have been paid and suppliers, etc. When in reality, you're waiting for that money to come down so that you can make that payment. So that whole issue is resolved if the waiver itself is simply conditioned upon receipt of payment. All right, perfect. I finished. I got so a few minutes here to take any questions if there are any.
Do you have it? Can you see any questions in your chat feature, Mike? That's what we were asking people to ask them in that fashion. Because Sue does have some, she's going to bring them into me. I'll read them off because they're not showing up on my side either.
I have one gentleman asked why the responsibility or liability language for subs is essentially not the same as for the primes. You find that a lot. So prime contractors sometimes have their own standard form contracts that they use, and especially on public projects where their contract with the owner may allow for, let's say, delay damages under certain circumstances, but then they in their subcontract specifically exclude delay damages. Why that is? Well, it's kind of obvious, because the GC doesn't want to have to incur those potential claims, but it wants to preserve the right to present them to the owner.
I have 2 more here, Mike. For some reason, they came through on Sue's system, but not on mine. The first one is when an owner or an AE are acting unreasonably, for example, really stretching interpretation of the contract documents, adequate documentation of notice, for example, what is the best approach for the contractor to take?
So that's very issue dependent, right? It really depends upon factors like what's your relationship with the owner, what's your relationship with the GC, how much work are you expecting to get in the future from both entities. That's going to play into how you approach it. When or if you get counsel involved, what type and the content of, let's say, a demand letter or a letter to the architect and owner, putting forth your claim. It really is highly dependent upon the project itself, how much money is at stake, things of that nature, how far you want to escalate it. Much easier to deal with the issues on the front end when you're negotiating the contract than on the back end.
I've got a few more here, Mike. This one's a little bit technical. It deals with BIM, but I'll read it off. I may have misunderstood the part about coordination, but if a BIM model is considered a contract document and a contractor is required to take a model from level of detail 300 to 350 to level of detail 400, then the subcontractor is obligated to review and highlight constructability issues after awarded, and most time that level of coordination occurs after the contract issue. Therefore, then, the subcontractor is responsible for constructability with a question mark.
Yeah, lost me about halfway in there, but perhaps they're asking, you know, some of these project documents are going to be developed after the fact, and so how do you deal with conflicts there? I think just in general, it can never hurt to put the architect on notice of anything you review. As far as your responsibility, that's going to be dictated by the language right in the contract. Whether you're responsible for just constructability or whether it includes code compliance, things of that nature, that should be right in the contract or the specifications.
Here's another question. As a subcontractor, which of these documents, in parentheses, AIA or consensus docs, would you suggest to the prime contractor if theirs is too stringent?
Honestly, I like aspects of both. I've been reviewing and revising AIA documents for probably 12 years. Consensus docs, a little less than that. Consensus docs tend to be on the owner contractor level. Their default is, in my view, more contractor friendly than the AIA. AIA tends to default, it's not a surprise, to the owner / architect on various issues. That being said, if you're a sub and you can get a contractor to execute a unmodified consensus doc or AIA doc, you're likely going to be in a lot better position than signing their modified contract, because both documents, if they're unmodified, yeah, they might favor one party or another, but it's not nearly as one-sided or egregious as you're going to find in a modified contract.
Couple more questions. If a contractor submits an unconditional lien waiver, can he later state to a third party not involved in the payment process that the waiver was void because he didn't receive payment? And then they have in parentheses, unconditional lien waiver was signed in error.
Yeah, that's a pretty specific question. I think that'd probably be kind of a fact investigation there. I'd have to review that with you offline.
Okay. And one more. I was under the impression that regardless of the waiver of lien, conditional or non-conditional, it was against the law regardless to hold the sub's payment. Yeah,
so that is actually a complex issue. And you're dealing with, I think one of our panelists will cover this, the pay when paid versus pay if paid clauses. New York obviously restricts any pay if paid clauses. Doesn't stop contractors from putting them in there, owners from putting, people from putting them in there, but they may be there. Again, whether or not it's actually enforceable or against public policy or legal in New York is one question. The first question is, are you able to spend the resources to find that out?